Good morning, everyone. I'm going to go through our fall employment compliance checkup today. I hope everyone can see the screen all right. Okay. So just to start out, just with a legal disclaimer, the information and material in this presentation should not be construed to be legal advice, nor the information forming a lawyer-client relationship. So the first thing on our agenda is the new Form I-9 has been unveiled. So as some of you might know, it kind of took a while to get the new Form I-9. I believe it had expired sometime late last year, I think October of 2022, and we were kind of just waiting on it, not sure when we were going to receive it. We finally did get it. I believe it was in August. And there were some changes. It looks a bit different than our previous 2019 version. So I'm going to go through, I'm going to have the picture of the new I-9 and kind of go through some of those changes. And then the most important things that employers need to know. So here, as we can see, on the left-hand side, we have the new form. As we can tell, it's been really consolidated. It's now a single page rather than those 2 pages like it was previously. So it reduced sections 1 and 2 to a single sheet. No fields were removed, but a lot of fields are pretty much merged into fewer fields when possible, such as the employer certification. Another additional change was that they moved section 1, the prepare translator certification area, and that's now supplement A. So employers can use that, attach it when necessary. A lot of my clients don't really use that, which is likely why they created that supplement. Kind of as a just in case, you can just tack it on to the normal Form I-9. This supplement, it does provide 3 areas for current and future preparers and translators to complete as needed. And like I mentioned, employers can attach additional supplements as needed. If you might need more than one supplement A, you're more than welcome to kind of attach a new one on there. It also moved section 3, the re-verification and rehire, to a standalone supplement B. Employers can use this as needed for rehire or re-verification. So that as well, that kind of used to be at the end of, I believe it was page 2 towards the bottom. That's now just been switched over to supplement B that you can attach whenever it needs to be used. Another thing that was changed was it removed the use of alien authorized to work in section 1, and now it replaced it with a different term, non-citizen authorized to work. And also the Form I-9 instructions do clarify the difference between a non-citizen national and non-citizen authorized to work. So that's kind of important if you have some employees who might fall into those categories. You might want to read up on the Form I-9 instructions just to see if that might change the way that you normally complete your Form I-9s with new hires. Another change was that it ensured the form can be filled out on tablets and mobile devices by downloading onto the device and opening in Adobe Acrobat Reader. So it made it a lot more accessible, electronically accessible now, so you don't necessarily have to deal with all the paper copies of the Form I-9. It also got rid of the requirement to enter not applicable in certain fields. So this was something big that I'd see if I'd go and do I-9 audits with a lot of my clients. If the employee didn't have a middle name, they were supposed to put NA in that box, or if they didn't have an apartment number, they were supposed to put NA. They got rid of that requirement now, which makes it easier on employers, so you don't now have to know, oh, well, this box can't be left blank, I need to put NA here. That requirement is done with. Also, it improved guidance to the lists of acceptable documents, and this now includes some acceptable receipts, guidance, and further links to information on automatic extensions of employment authorized documentation. Also added a checkbox for our E-Verify employers to indicate when they have remotely examined Form I-9 documents. And just to add in as a reminder, this isn't part of a slide, but if you are not using E-Verify and you are under those COVID rules and kind of more lax regulations where you were remotely examining your Form I-9 documents for those employees who were working remotely, maybe out of state, you now need to have a physical inspection of those documents. You have to have someone verify that those documents are accurate and sign off on those. So that's something that is recently changed, and that's something that everyone, if you haven't already done that, you should start to prepare for that as well. So, what are some things that employers need to know with this? So, you can continue to use the previous 2019 version through October 31st. So if you'd like to keep continuing to use the older version, you're more than welcome to do so through October 31st. However, beginning November 1st, you do need to start using that new 2023 version of the form. You don't need to have current employees fill out the new version of the Form I-9 because of this new release. So every time a new Form I-9 comes out, it's not required unless there's the government says something otherwise. You're not required to have them fill out a new Form I-9 with every new version that's released. So there may be a requirement to update documentation if employee re-verification arises. However, you don't need to have them fill out a completely new form. Another just important thing to note that I should throw in here is that you must keep original I-9s on file for all employees for either 3 years after the date of hire or 1 year after the date employment ends. So whichever one is later. Something else that's important now that we have this fresh new I-9, maybe you want to take a look and do an internal audit of the Form I-9s that you currently have, which I always feel is a good idea. A lot of the times they're filled out incorrectly. So a lot of clients will often ask, well, how do I make changes? Do I just have to fill out a whole new Form I-9 whenever there's a slight mistake or omission, some type of error on an employee's previously completed I-9? That's not always the case. So specifically with section 1, you want to have the employee correct those errors. So that's the part where the employee fills out themselves. You as the employer don't want to try and correct those errors. You want to have the employee correct those where they provide their own information. So say maybe they misspelled their name, misspelled their address, something like that. You want to have them correct that. What they can do when they correct it, either if there are multiple errors, we can have them do a new Form I-9. If there's few errors, we can just have them draw a line through it, which I'll speak about in a bit. So if the employee needs assistance to correct these errors with either a preparer or a translator, then that preparer translator should make the correction or note the omitted information, or they can help the employee to do so. So if the translator or preparer needs to complete a certification block, they need to do that as well now if they haven't completed one in the beginning. If they did complete one when the Form I-9 was originally filled out, then they're fine and they don't need to complete an additional one. So with section 2 or supplement B now, if there's multiple errors, you want to redo the section on a new form and attach it to the previously completed form. We understand that those spaces on the Form I-9 are really small. It might be hard to kind of correct a lot of errors in that small amount of space that you have. If you feel like there are too many in there, feel free to just get another form and stick it on the back. So like I mentioned, if there's just a few errors on either section 1 or section 2, You can draw a line through the incorrect information and enter the correct information. So like I mentioned, if it's section 1, have the employee draw the line and enter in the correct information or enter in the previously omitted information. If it's section 2, which was the employer's responsibility, then the employer can go ahead and cross out the incorrect information and enter the correct information there. So you also should initial right by your correction, employee initials and or prepare translator initials if applicable for section 1, and then employee initials, and then employer initials for section 2. And then you're going to date the correction or previous omission. There should always be initials and a date by either the correction or omission in the Form I-9. And another thing that I always advise my clients with is attach an explanation of the changes made to the existing Form I-9 or the reason that a new Form I-9 had to be completed, and just sign and date it. You can just put HR entered this incorrectly. Some type of simple explanation just in case the worst happens and you have ICE coming to check your I-9s. They can quickly see that there was good faith on part of the employer, that they tried to make these corrections, add in previously omitted information, and they have an explanation signed and dated with it. Another important thing to note is that you don't want to conceal any changes made to the Form I-9. So for example, you don't want to erase any text or use whiteout or anything. And you don't want to backdate the Form I-9. So if for some reason you didn't fill out that little section for the employer within those 3 days after hire, don't backdate it. Just put the correct date, and then you can always put an explanation if you feel necessary to the end, just to show some good faith. Also, like I mentioned, the explanation, sign and date it, and just kind of file it away with that Form I-9, and that should do it. So the next thing up on our agenda are marijuana discrimination concerns. I know some of my clients are a little bit eager to get more information on this, as I had kind of warned them about it last year. So the law got signed last year, however, it's not taking effect until January 1st of 2024. So we're going to speak about this a bit. So it's AB 2188. Like I mentioned, effective January 1st, 2024. This generally prohibits employers from discriminating against a person in hiring, termination, or any term or condition of employment, or otherwise penalizing a person for using marijuana off the job and off-site away from the workplace. It also prohibits relying on certain drug testing, which we'll speak about in a bit as well. So I feel like this is very important. This does not apply to employees who are in building and construction trades that require federal government background investigation or security clearance that is in line with regulations issued by the Department of Defense. This also does not preempt any state or federal laws which require applicants or employees to be tested for controlled substances. So this has to do with a lot of employees. If you have employees that have to follow Department of Transportation regulations, that's still on the table. That random drug testing, whatever is required by the Department of Transportation, that's still on the table, and this section does not at all interfere with that. So I feel like that's very important to understand. This will apply to most employers, but it won't apply to all employers in California. So like I mentioned, the employers cannot discriminate against an applicant or employee for failing a drug test, which is detecting those non-psychoactive cannabis metabolites, which are found in either hair, blood, urine, or other bodily fluids, however the drug testing mechanism works. This law aims to only test THC, which is the psychoactive metabolite that's responsible for the intoxication. So what this does, like I mentioned, it's protecting that employee's off-duty and off-site marijuana use. As we understand, it's legal in California, illegal under federal law. However, California is protecting an employee's right to be under the influence of marijuana when they're not at the workplace. So now with this law in effect the beginning of the year, if you're sending an employee to do drug testing, that drug test is going to have to identify THC, or it's going to have to be an impairment test, which is checking an employee's pretty much their normal behavior compared to how they're behaving at that point when you believe that they're impaired. So like I mentioned, that impairment test there. So this I know a lot of employers are very worried about, which makes sense because I think the headline here is, oh, employers can no longer discriminate against employees for their use of marijuana. However, there is a caveat to that. So you can still require that employees are not impaired or use cannabis on the job. This in no way affects the rights or obligations of an employer to maintain a drug and alcohol-free workplace. So if that's a policy that you already have in place, that's great. So you can keep that up. You don't now have to allow people to come into the office impaired with marijuana, or they can't like smoke it on premises during their rest or lunch breaks. This is just stating because those non-psychoactive metabolites can stay in someone's system for a long time, we can no longer just test that and terminate an employee just because those non-psychoactive metabolites are found in the system with the drug test. So some of our recommendations are just making sure, like I mentioned, that there's a proper alcohol and drug policy in place. You want to keep an eye out for an employee's behavior and really use the reasonable suspicion test. You can't just assume that someone has been smoking marijuana or that they're impaired on the job. You really want to make sure that you find reasonable suspicion and that you document it. And also, when you send an employee over to the clinic to get drug tested, make sure that they're using the proper drug test that's going to test for that THC and not for those non-psychoactive metabolites, because at that point there's nothing really you can do with the results of that test because it didn't test for the correct metabolite of cannabis. Some more important information that was just recently updated are background check insights. So for all of my employers who are doing background checks, I know there's already a lot of hoops to go through in California when a non-satisfactory background check comes up. You kind of have to send that pre-adverse action letter, consider all of the factors that go into it, mitigating circumstances. And basically what California did is made this just a bit harder. And there's more factors now for employers to consider. So we'll discuss those a bit in detail. So there were certain considerations that employers already had to have in the back of their mind when an unsatisfactory background check fell into their lap. And now California has expanded on these factors and have kind of given more information on employers as to what to look for. So the first one that had already existed previously was the nature and gravity of the offense or conduct. They've said that some considerations that go into this specific factor would be the specific personal conduct of the applicant, which resulted in the conviction, whether the harm was to property or people, degree of harm, permanence of harm, context in which the offenses occurred, whether a disability such as a drug addiction, mental impairment had contributed to this offense or conduct, and the likelihood of harm arising from similar conduct, whether trauma, domestic or dating violence, sexual assault, trafficking, duress, similar factors contributed to the offense, and or the age of the applicant when the conduct occurred. So those are all important things to think about now and to kind of add to your list of when you're trying to judge the nature and gravity of the offense or conduct. Time that's passed since the offense or conduct and or completion of the sentence. So you want to look at the amount of time that's passed since the underlying conviction, which may significantly predate the conviction itself. So if someone had a conviction 20 years ago, that's something you should really take into consideration rather than someone who's had a conviction maybe like last year. You kind of do have to weigh that out and look at those timelines. Also, whether the conviction led to incarceration, the amount of time that has passed since the applicant's release from incarceration, some other things to think about there. The nature of the job held or sought. You want to look at the specific duties of the job. Will they be handling your client's personal information, social security numbers? I have a lot of property managers that have social security numbers, bank statements. I mean, you want to really take a look at those specific duties and know what information they'll be privy to, maybe what kind of tools they'll be using, what they'll be doing with clients. Will it be very client facing? And kind of take a look at how that plays upon the things that they have been convicted for or some marks on their record. You also want to look at whether the context in which the conviction occurred is likely to arise in the workplace. So this would be maybe someone had been convicted of fraud or stealing people's credit card information. Going back to my previous example, maybe you write down that you feel like the conviction occurred is likely to arise in this workplace because they're an apartment manager and they have all of this private information, private financial information from your tenants and clients and things like that. So it's very important to keep that in mind. Whether the type or degree of harm that resulted from the conviction is likely to occur in the workplace. Evidence of rehabilitation or mitigating circumstances. This is something else that California wants you to look at when you get a non-satisfactory background check that comes in or one that has some marks on it. So you want to look at the length and consistency of employment history before and after the conduct, facts or circumstances surrounding the offense or conduct, applicants' current or former participation in self-improvement efforts. Maybe this is like a rehabilitation program, a job training program, therapy, counseling, whether trauma, domestic or dating violence, sexual assault, stalking, human trafficking, duress, or similar factors contributed to the offense or conduct. This is somewhat similar to a consideration we previously discussed. Age of applicant when the conduct occurred, whether disability, like we mentioned, this drug addiction, likelihood similar conduct will occur, fact that applicant is seeking employment, successful completion or compliance with terms and conditions of probation or parole. So this kind of takes a few from the previous considerations, it tacks them on to this rehabilitation or mitigating circumstances, these factors to consider, and then also just have they successfully completed the terms of conditions of their probation or parole. That one's a new one in this specific section here. That's a good thing to think about when you're trying to analyze the rehabilitation or mitigating circumstances. You also want to look at the documentary evidence, and what they've expanded upon here are certificates or other documentation of participation or completion, letters from current or former teachers, counselors, supervisors, coworkers, parole or probation officers, almost kind of like a letter of reference there. Police reports, protective orders, and or documentations from healthcare providers, counselors that can attest to the applicant's status as a survivor of domestic or dating violence, sexual assault, stalking, or comparable offenses. Documentation confirming the existence of a disability, and any other document demonstrating rehabilitation or mitigating circumstances. So as we can see, a lot of these play upon each other and really should all be thought about when we're deciding to send this pre-adverse action notice letter. So you might be thinking, well, I'm not privy to all of this information as the employer. What you can do when you send that pre-adverse action letter, you can always request that they send some documentation to kind of help you go through these factors and make your decision. You cannot mandate that they send documentation or any certain documentation, but you can request that they do so, just so that way it can help you with your considerations, or your hiring manager or HR, their considerations when they're thinking about whether or not to hire someone, promote someone after that conditional offer has been put out on the table. So, since we talked about things that employers should do when a background check with some errors comes on their table, let's also talk about employer prohibitions. So, refusing to accept additional evidence voluntarily provided by an applicant, you want to take as much as you can. Whatever the applicant provides to you, you do want to take that and take it into consideration. So, don't just accept the documents and kind of throw them on your desk. You do want to consider those documents as well. Another thing also to look at is requiring an applicant to submit any of the additional evidence described in that section at any time during the hiring process. So like I mentioned, you don't want to require any documentation from the applicant, you want to request it. So that's kind of the difference there, require versus request. Requiring an applicant to provide a specific type of documentary evidence, like the police report as evidence or domestic or dating violence, or disqualifying an applicant from employment conditionally offered for failing to provide any specific type of document or other evidence. You also don't want to require an applicant to disclose their status as a survivor of domestic or dating violence, sexual assault, stalking, or comparable statuses. You cannot require an applicant to produce medical records and or disclose the existence of a disability or diagnosis. And some of you might know that kind of can cross the line into not only kind of this discrimination based on like a criminal past, but more so discrimination based on a disability or some type of medical diagnosis. We want to steer clear of that as well. So California also clarified the notification requirements, and the deadline for the applicant to respond. So must be at least 5 business days from the date the receipt of a notice. You have to give an applicant at least 5 business days from the receipt of notice that you're considering an adverse action on their application because of their background check. You have to give them those 5 days to respond and provide their mitigating information, any information that you might request, like I mentioned, request not require, any information that you might request. You want to give them that time to respond to that inquiry and kind of provide why they feel they should be hired. Maybe, like I mentioned, they've been through rehab, or the conviction was 15 plus years ago, different things. There's not a magic number for the conviction, but just was such a long time ago that they feel like it was different. Maybe this was a conviction that they got at 18. So just providing them those 5 days to really give you information, hopefully mitigating those circumstances. So the written notice mailed by an employer without tracking delivery enabled is considered received by that employee or applicant, received 5 calendar days after the mailing is deposited for delivery. And this is for California addresses. They've also clarified that it's 10 calendar days after the mailing for addresses outside of California and 20 calendar days after mailing for addresses out of the United States. So those are important things to consider as well. Email notice is considered received 2 business days after it is sent. So if you send that pre-adverse action notice through email, you wait 2 business days, assume that it's sent, and then you give them those 5 business days to respond after that. So those are just some things that are new with background checks and just some additional information, some clarification that has been made in California. Our next topic is navigating personnel files. So this is always important to just kind of take a look through your personnel files, maybe do it just periodically, check to make sure the correct information's in there, make sure that things that don't belong in there are placed elsewhere, and we're going to discuss a little bit about that. So in California, as in many other states, maintaining accurate and complete employee personnel files is really essential for employers to ensure compliance with labor laws and to really protect employer interests. So while there isn't a specific legal requirement for the contents of employee personnel files in California, there are certain documents and records that are typically included in these files. So it's essential to maintain confidentiality, ensure that access to these files is limited to authorized personnel. So just to kind of describe a bit, so employment application, so a copy of the employee's initial job application, their resume or their CV, that should be kept in file in their personnel file. The job offer letter or employment contract, you want to include a copy of that signed job offer letter or their contract, which outlines the terms and conditions of their employment. That should be kept in there as well. Tax forms, their W-4, their DE-4 for California, their emergency contact information. We also want to make sure that that's up-to-date emergency contact information for employees. So if that even means when you're doing the personnel file, maybe sending a memo out to all of your employees, letting them know, hey, is your emergency contact information, please make sure that that's still correct information, or if you'd like us to update it, please let us know. Things happen all the time, divorces, marriages. We want to make sure that we have the most up-to-date information so that way, if there is an emergency, you have the correct person to call. Any kind of payroll records, like the records of an employee's salary, wage rate, or any changes or adjustments. We also have performance reviews. Any performance evaluations, performance improvement plans, disciplinary actions taken during the employee's tenure, make sure to include those in the employee's personnel file, as well as employment policies. Copies of any signed acknowledgement forms for your employee handbooks, copies of conduct or workplace policies that they've separately signed off on. Your drug and alcohol-free workplace policy, that might be a separate document not attached to your employee handbook. Once they sign it, throw that in their personnel file as well. Also, your training and development records include documentation of any training, workshops, maybe certifications that the employee has received during their employment. Attendance records, they're records of attendance, any related documentation. If they have a consistency of being late, consistency of being absent on certain days, maybe a Monday or Friday, you want to have that documented, and we'll put that in their personnel file just to see if there are any patterns or anything else, if that relates to maybe some disciplinary actions. We just want to have all of that information easily accessible if needed. benefit information. We want to include documents related to the employee's like retirement plan, other benefits that might be included that doesn't have any personal medical information. We can put that in the personnel file as well. Termination documentation. So if applicable, you want to maintain the employee's records related to the employee's resignation or their termination or separation. So their exit interview, any documentation, maybe you want to keep a copy of that final paycheck in there as well to prove that all their final wages were paid out on time and that all of them are paid out correctly. And like I mentioned, yeah, performance improvement plans, records of these performance improvement plans, progress notes. Another big kind of item you want to have in that personnel file or our correspondence. So any type of significant employment related correspondence between the employer and an employee should be included. So letters of reprimand. Maybe you don't have a formal disciplinary notice that you sent to this employee, but you have an email that kind of reprimands them because they were late or they were had an unexcused absence. Things like that you want to put in their personnel file as well, because it's so difficult when you get, say that you terminate them, they have an attorney that they hire for wrongful termination, and you're trying to dig through your emails to try and provide documents to your corporate counsel to say, oh, you know what? No, I know that we admonished him for being late on, I know I sent him emails. You want to have all of those prepared. So just print out the email or download the email so it's a PDF and either put it in their electronic personnel file or just print it out and stick it in their hard copy, stick a hard copy in their paper personnel file as well. So what isn't kept in a personnel file? I think this is just as important as knowing what is kept in the personnel file. So it's really those confidential records, any confidential or sensitive documents such as medical records. I even don't like to have medical leave requests in there because oftentimes the medical leave request states some type of symptoms, or sometimes it will incorrectly state like a diagnosis in those records requesting leave, and we don't want those medical records to be mixed in with the personnel files. Other things that are confidential or can be considered confidential, the background check reports. Those could all be kept in separate, secure files. Another thing that I like to have kept in a separate file are your Form I-9s. And this protects the employer because you want to have all of those ready to go if there is some type of ICE inspection, if there's something that happens and you need to have those all in a separate location. You don't want to hand over ICE all of your personnel files that has everything included, the employment applications, everything. No, you want to hand over just what they're requesting, what they need. So I always feel like it's best to have those Form I-9s all in kind of one separate file or binder. And what you can do is separate them from current employees to past employees. And of course, like I mentioned, you usually need to keep those past employee I-9s on hand for that year requirement or the 3-year requirement, like I mentioned. So those are just very important to know what shouldn't be in that personnel file. And if you kind of you can go through a few personnel files and just see what the practices are. There's also some personnel file privacy suggestions. So, like I mentioned, the personnel files contain personal information and often private information about an employee, and employers should ensure that proper privacy is implemented. So, by some of the following here, we have secure storage solutions, maybe some encrypted digital storage for electronic records, or if you have all paper hard copies, lockable secure cabinets for physical files to really prevent that unauthorized access or breach. Access control and logging. You want to limit access to personnel files to designated HR staff, and You can also implement some stringent access controls, which like maintain detailed logs, and you know who's been in and out of those personnel files, and even kind of going, if you have those hard copies, maybe only having a set number of keys and listing out who the keys belong to, and having that so that way you know who has access to all of those files. We also have regular audits, and this is something that you should periodically review your personnel files just to make sure that you understand how all of this data is being stored and that it's being stored in the most proper way. Also have ongoing training. Ensure that your HR and related staff receive continuous training on how to really protect your employees' privacy. It helps your employees just feel safe with their employer, but it also helps ensure that there aren't any type of data breaches with your employee information. So our next slide is handbook update strategies. As we're inching closer towards the end of the year already for 2023, it's important that we think about how we want to update and maintain our handbook. So, of course, we have those regular compliance checks that we ensure our handbook aligns with current laws and industry regulations. We want to stay updated with resources like HR journals, legal updates, government websites. Another important aspect to look at is feedback loops with employees. How do we want to make our work site a better place? We want to encourage staff to suggest changes or provide feedback on the handbook's content. Of course, they can't change anything that's like a legal requirement or any kind of legally required portions in the handbook. However, they might find that, hey, this benefit that the company pays for doesn't really apply to a lot of employees. Maybe we want to look at some other benefit plans, or just having that employee suggestion might help take your handbook in a new, better direction. So just consider maybe setting up a digital suggestion box, or maybe holding just annual feedback sessions. Another thing to look at, have your cross-functional teams, have them review. So include multiple departments. It shouldn't just all fall onto HR. Think about your operations department, all of your departments, to make sure that the policies that you have in your handbook are actually the policies that are being implemented in the workplace. So technology and software integration as well. So you maybe have these cloud-based handbooks. You want to make sure that the updates are instantly accessible to all employees. How are you distributing your handbook? Is it through technology? Is it hard copies? Just things to think about based on your workplace. Digital handbooks might not work for all employers. Maybe you have a landscaping company and you have a lot of employees who aren't working in an office. Digital handbook might not be the best bet for those employees. Maybe you want to provide them hard copies. So just trying to think about how you can integrate technology and software where you can do it. And of course, when you update and maintain your employee handbook, if it's overwhelming, make sure to reach out to your CalWork safety and HR consultant so they can help you get your handbook updated and ready, especially if it's been a couple years. There were many significant changes that were effective 2023. So it's important, if you haven't updated your handbook for 2023, that you get that going. I'm also going to discuss a little bit on HR and safety assessments. I know we're running a little bit short on time, so I'll go through this pretty quickly. But CalWork Safety and HR is really there to provide you with an HR or safety assessment. It's really what the company does best. Go in there and figure out some issues, some underlying HR or underlying safety issues. If you want to do it separately, or if you feel like you need both, they can really be performed in one sitting, or you can schedule them out, parcel them out a bit. But this really helps just to ensure that you're operating a compliant and safe workplace, and really peace of mind, especially being a California employer. If you wanted to conduct an HR assessment on your own, You do want to have proper preparation and planning. Define your objectives. What do you want out of your HR assessment? You can even do this for a CalWork Safety HR assessment. Decide what you want. Are there certain areas that you would like to see improve? Maybe employee turnover, maybe kind of just there's certain things there, employee attendance issues. What can we do to help your company and with your company's needs? So you're going to want to gather your relevant documents and identify the stakeholders. Who are some of the key stakeholders? HR staff, managers, employees, who should be involved in this process? Also want to look, of course, at compliance and legal considerations. Are you compliant with your labor laws? And like we mentioned with your employee handbook, is the employee handbook in compliant is with current laws and regulations? And does it ensure that, or you want to ensure that it reflects the company policies accurately? Also want to take a look at recruitment and onboarding. So how are we onboarding our new employees? Could that be cause for employee turnover? You don't know until you really start digging and looking in there. Also look at your employee relations and engagement. So it's important to look at employee feedback, some conflict resolution strategies, employee recognition, maybe review programs for recognizing and rewarding employees for performance and contributions. Some other things to look at are performance management. So you have your performance appraisals, goal settings. What's the process for setting and communicating? The most important part is communicating those goals, those individuals and team goals to your staff. Compensation and benefits. Look at your salary structures, your benefit programs. Does it have certain perks that keep you competitive in the market when you're looking for employees? Training and development, your training needs analysis. So identify areas where employees do need training. And then maybe even succession planning. So evaluate the organization's succession planning and talent development efforts. As you have, maybe there's some people in certain departments that are close to retirement. So you want to make sure that we have more people to fill in once those employees retire. So what does that look like for your company? Another thing is HR technology. So any kind of HR information systems that you might have. CalWork Safety, how can us as CalWork Safety third-party HR consultants help your company out? How can we help strategize with you for just efficiency, accuracy here? Record keeping and documentation, your personnel files, make sure that they're complete, accurate, well organized. Look at your data privacy. Make sure that you're having you have like your security in place and things, your data and your employee information is all secure. So you want to make sure that you have that and keep that in mind as well. Employee exit processes. These are very important as well. So your exit interviews, how do you conduct them? How do you collect feedback? Documentation and reporting. Summarize assessment findings and recommendations for improvement. You want to develop some type of action plan that identifies those deficiencies and implements improvements and communicate those results with HR staff, senior management, whoever the stakeholders are. Your safety assessments. It's really important to have a safe and healthy working environment. Same here, you want to define your objectives and identify your stakeholders. You want to review your safety policies. What safety policies do you have in place? Offices require safety policies as well, and that's very important. If you have an office and you're like, oh, we don't really need all that, we don't work with heavy machinery, that's completely wrong. You do need safety policies and practices in place. It might be slip, trip, and fall, or maybe ergonomic training. Look at your regulatory compliance. Are you meeting all of your Cal OSHA standards and regulations? Physical safety inspection, just walk around your workplace. That's always a good way to see, are there a lot of extension cords all over the floor causing trip hazards? Are there spills in the bathroom? Maybe water is around the sink and we don't have proper mats there to soak up that water, or non-slip mats. So those are things to look at. Look at those hazards and also look at your emergency preparedness. Does your company know what to do if there's a fire, an earthquake? What are these steps that the company takes to ensure employee safety? Safety equipment and gear, PPE. So sometimes this could be safety glasses, hard hats, respiratory masks. Look at your equipment maintenance. Make sure that your fire extinguishers, your alarms, safety eye wash stations, that those are regularly inspected and maintained. And then your chemical and hazardous materials. Make sure you have an inventory of these hazardous chemicals and you have your safety data sheets in place so that way they're very accessible. You also want to have employee training. Make sure that you have employee training so that way you can show if Cal OSHA knocks on your door, you have the documents to show, hey, you know what? We do maintain a safe and healthy workplace, and we provide training every couple weeks, every quarter, whatever it might be, and we have all of our plans in place. Also want to make sure that you have a good safety culture. Assess your organization's safety culture and employee attitude toward safety. How can we make that better? How can we make them want to stay safe and want to take these extra precautions? Also, incident reporting. Review your procedures for reporting accidents, near miss incidents, and injuries, and evaluate the process for investigating and analyzing these safety incidences. Also want to look at your security protocols. Do you have a visitor sign-in, protection against workplace violence, maybe active shooter training? That's something also that CalWork Safety and HR provides. What do you do when there's an active shooter in the building? These are all very important things. Of course, we don't want to think about them, but important things to keep in mind because they are a possibility. Safety data and metrics. Identify and measure our key safety metrics like near miss reporting, incident rates. Also want to look at the findings and recommendations. So like I mentioned before with the HR assessment, summarize your findings, get an action plan together, communicate, monitor, and follow up. So that ends a big bulk of our presentation, and I just wanted to let you know that Victoria Hill and I, you might have her as a consultant. She is also a consultant and attorney. We've created our own firm, Employer Legal and HR Solutions. It's really we're trying to continue Don Dressler's legacy of providing quality work to clients and just truly caring for clients like he did. We feel like that's so important and really invaluable, especially when employers are in a hard place with claims or complaints. We do offer many services such as workplace investigations, EDD audits, DOL audits, contract drafting and document review, as well as administrative hearing defense, such as civil rights department or equal employment opportunity. We have our contact information there. If you'd like to learn more, please reach out at info@legalandhr.com, or also our office phone is listed there as well. So thank you.
Thank you, Kayla. Do we have any questions in the chat? Go ahead and drop your questions if you have any.
And
All right. If we did not address your questions today, go ahead. Oh, looks like we have one. For the I-9, can you enroll in e-Veri to allow for remote verification?
So I believe that you can enroll in E-Verify, but I don't know what that process actually looks like. You can sign up for E-Verify, but it might differ kind of based on your company. Screen. Okay. Okay. And Rochelle, yes. So if you're not in or if you're not an employer who uses E-Verify, you have to review those in person. If you have, say, you're a California employer, but you have employees who might be in Texas, you can have them go to someone who has experience in reviewing I-9 documents. That could be a notary, could be someone you kind of want to call around. I don't suggest having like an employee's friend or family member do it, just because if they don't do it correctly, that error falls on the employer. So you want to make sure you have someone who knows how to review them and knows what they're looking for and how to fill out that employer verification section on the I-9.
All right, any more questions? So again, if we didn't address your questions, go ahead and reach out to us at info@calworksafetyhr.com. Thank you so much for sharing, Kayla, and thank you to everyone for joining us. Have a wonderful rest of your day.